I never want that to be how the conversation starts. So, you know, when I'm involved on the front end, I'm definitely in the midst of it. If it's the back end, I immediately say, oh wait, we got Minnesota cases. What are those about? Who's the judge? Let's, you know, who's controlling that? Who's in, anyway. So I could go on and on. I know we have so much to talk about. This is a great segue to what comes next. And yes. I turn it back to Lance.
Thank you, Brandy. Thank you so much for that overview. And let's go on to the next slide. Well, given what you've just heard about the oftentimes immense moving parts associated with a large-scale MDL, Sharon, how in the heck can you settle a case or cases on behalf of your clients? How do you estimate settlement values? What are the tools that you use? How do you tackle such an unwieldy beast?
Well, how do we get to settlement already? What happened to everything else that goes on in this case? It's such a great question, and you know, I was actually on the phone this morning with a client in an MDL that actually has a global problem, and I mentioned that it's time to start thinking about settlement, and my client said to me, Sharon, I do not want to utter the S word. But whether or not you're going to utter the S word, I think you need to be thinking about the S word at all times and all stages of your litigation. I think this is so I think this is the right place for this slide, and I think it's such an interesting topic title, because it says estimating settlement values, not estimating damage values, because they're very different things, right? And I'm going to sort of invite Peter into my section if he wants to join at any point, because I will plainly come at this with my own biases, and I'm sure Peter will have some of his own that will be very valuable to this conversation. But as I said, you know, first of all, what is the settlement value? In my view, the settlement value is the place where the Venn diagram of what Peter's client wants and what my client is willing to pay intersects. And you know, and what where Rod gets us to agree is, so that is what the value is. And it is not a static number; it is a point in time number. You know, it moves as facts change and priorities change for the clients, and so there are going to be different ways of valuing settlement, and there's amounts, and there's going to be different reasons and times. And again, just as this is a sort of an interesting moment to have this conversation in the slide set, it's also interesting that the first bullet here is mediation. Why are you starting with mediation? And again, interesting because I think Ron knows I actually really value the idea of early mediation in complex litigation. And when we're talking about MDL, we are per se talking about complex litigation. And I think one thing that people who are new to MDLs need to think about when they're thinking about settlement is, what does the fact of the MDL mean for settlement valuation? And one thing that you need to think about is that the odds are pretty high that your case is going to settle in the transferee court. And if you are not lead counsel, or if you're not a member or a key member of the plaintiff steering committee, you may find that your case is going to be settled out from, I don't want to say settled out from under you, but the case is going to be settled without a lot of input necessarily from you. So that you may not have a lot of input into that, to valuation of that. But I find that particularly in this kind of a situation, an early mediation or early conversation can be incredibly valuable. And one of the things that can happen in terms of one of those mediations, especially when you're dealing with an MDL, where you often have a lot of lawyers who have a lot of point of views, will be to come in and hear how they're valuing. Ask them to come in and explain to me how they're valuing these cases, what they're thinking about these cases, what the nature of the case will make a difference. But are these going to be cases that require individualized damages calculations? Is there are we going to need some kind of matrices? Are we going to need to have some kind of master who's going to look at individual? I'm sorry, I need to click something that, yes, I am actively still attending.
This is for attendees in states where you have to verify that you're still with us. So give us a moment.
I apologize. I don't know how to get out of
this. We'll go back in a second.
Okay. There we go. I'm back. Sorry. So there are, but I do think that kind of mediation and an early mediation, even if the understanding is going to be that the odds that it's going to end in resolution can be quite valuable. There's also a real value in I think the lawyers learning each other, knowing each other, getting to meet each other early in the process, particularly as it is often the case in an MDL that the plaintiff steering committee will have a division of labor where the lawyers who are in the courtroom and the lawyers who are managing the settlement conversations are not the same or necessarily the same lawyers.
Sharon, excuse me. I'm sorry, Sharon, anything you wanted to add?
No, go ahead.
No, I just wanted to ask Sharon and Peter, since to me this is very interesting. MDLs are unique in that, it's almost an oxymoron, but with a bellwether trial, you could try a case, or multiple cases in order to settle the case. And it's probably a unique feature of the MDL world that these bellwether trials occur, and as we saw from 3M, are occurring in multiple bellwether trials to reach a overall settlement of the entire litigation. Can either of you speak to the unique nature of what is a bellwether and why do we have them in these MDL proceedings?
I think there's I think I consider, and I'd be, certainly we can jump to bellwether. I think there's a lot more here to also get to, but the bellwether trial is exactly that. It is, let's say you've gone through mediation, we've gone through previous settlements, and we should talk about that and experts and all of that, and let's get back to that. But let's say you can't reach resolution. You've mediated and you've gotten nowhere. You have what is referred to as a bellwether trial. It may be in the transferee court, as the judge noted. You may either need a lexicon waiver, or maybe there are some cases that actually belong in the transferee court, so you're able to have an agreement. But one way or another, you have or you send them back, but you are able to have a couple of agreed upon trials where you the plaintiff and the defendant agree that these are good representative cases. Maybe some sort of lean a little on the plaintiff side, some lean a little on the defense side in terms of facts and circumstances, where you can test, because you can't agree on a settlement value, you can test the value of these cases with a jury. And since the lawyers can't figure this out themselves, let's hear what a jury has to say about the value of these cases. And the purpose, that is exactly the purpose of a bellwether, so that you can then have a number that can go send you back so that you are able to resolve the remainder of these cases. Because if you are an MDL, and I have had MDLs where there's few as 4, 5, or 6 cases, but I've had MDLs where there are thousands and thousands, if not tens of thousands of cases, and you are not going to be able to do individual resolutions in those kinds of cases. If you really do need, and as the judge said, you're in an MDL for purposes of efficiency. I actually tried a bellwether case that started on February 14, 2020. It ended on March 12, 2020. So I flew back from San Francisco into New York City and landed on a plane and realized that there was a pandemic happening. I ignored that for the prior month, and within the next, as a result of that, it really was not the pandemic. It was the bellwether. As a result of that bellwether, there had been some 700 cases that could not resolve, and within the next month, they had all resolved. So, but Peter, any bellwethers?
Yeah, I mean, I think bellwethers are very are helpful. I mean, I think most judges would agree with that. They're not an exact science. You know, the 3M MDL is a perfect example because the verdicts have ranged from 1.5 million to, you know, tens of millions of dollars. So it's really not an exact science, but you do get a sense of what, number one, you do get a sense of whether a jury is going to find liability, and number two, what the range of damages are. So at some point, you know, you'll have enough of statistical information to basically say, look, these cases should be settled at X number. Of course, there's going to be a divergence of opinion about, you know, what that X number is between the defendants and the plaintiffs. But the reality is that it really just provides information about what these cases are worth. And it also, listen, it also, I think, helps the defense determine how much are they spending? What's their cost going to be in trying all these cases, or even an individual case? So I think it's very, very helpful in terms of setting a settlement value. But again, it's not an exact science.
Yeah, I think that's right.
And also, this is Rod speaking, and from the standpoint of mediation, I've been involved in a lot of medical device cases. They're all over the country, without naming any names of the companies. But the point is that when you go to mediation, not on one or two, but dozens of them in different parts of the country, and some settle, but the numbers that don't, the best thing that could happen is get into a bellwether trial with the understanding that that goes to trial, gets a result, but then with that, you've got dozens, if not dozens of cases that can be guided by that result to get that thereby back into mediation and try to resolve those, where otherwise they just everybody's guessing, and instead of having everybody have their own focus group, you've got a bellwether to kind of rely on, or bellwether trials to rely on.
That tends to be the rhythm, right? If you have a situation, and I have one now, where you have bellwethers where you have a zero, you know, someone has a great verdict. Let's say they have just for round number, you have $1,000 verdict, and then you have a zero verdict, and the next bellwether is a zero verdict. Then you have a range, and then they tend to rhythm back into mediation. It's easy if you have thousand or 0, 0, 0, and then they tend to collapse into easy settlement.
Absolutely.
But it's all information, and that's what estimating settlement value is. I think, you know, but when you get to the point where you're doing bellwether trials, you're really no longer at the point where you're at a point where the parties have ceded the decision making to somebody else. When you're doing early stage mediation, or even, you know, in discovery mediation, or working off a first stage settlement and doing opt out, what I refer to as opt out adjustment settlements, or then what you're doing is really, you know, these are party driven settlement valuations.
Right. Thank you. In the interest of time, I think we should move on to our next topic. And Randy, you already spoke some about your incredible work as a special master. Let's dig into it just a little bit more. And how are you? How vital are you to all of the pretrial discovery settlement processes of a large-scale MDL?
Well, I don't know that I'm vital, and I'll work with Judge Proctor on this. You know, these judges that have MDLs, they have an entire other docket. You know, they don't have just this case, and this case alone, you know, the MDL alone is a monster. So I've worked from the very beginning with the pretrial. It's really just keeping it going, knowing what's going on. You know, the attorneys live all over the United States. You know, I do a lot of we have a weekly call, or we have always have a status conference. But I think special masters, in my opinion, help move it along, because, you know, time is of the essence. It's very costly, but also the judge needs, you know, as much help as possible. They have law clerks. Sometimes they get an extra law clerk with an MDL, but that's just not enough. This is a lot. I've even sat in depositions because, you know, they're not going to be calling the judge and bugging the judge about things. I'm there. We can keep going. It's amazing. Just sometimes I call it a babysitter, but, you know, it's needed. I think it's helpful. I defer to Judge Proctor. Some judges want to do everything themselves, which is completely fine as well. But it's hard to separate your time and do it all if you've got a big load of cases. But Judge Proctor, any more insight?
Yes, I was invited to pinch hit for Judge Clemon, who's the chief judge on our court. When I first was appointed in 2003, he went to the green pastures of private practice about 10 years after that. And he was scheduled to be the keynote speaker at ACM in New Orleans right before the pandemic, actually, a few years back. And he had a conflict, couldn't, at the last minute, was unable to attend. So I pinch hit for him. And my keynote address as the pinch hitter was, all my heroes have been special masters. So I'm a big fan of special masters. And, you know, look, they can come in all shapes, forms, and functions. I used in the Blue Cross Blue Shield antitrust litigation, I used my special master to help with counsel selection. For some reason, I just thought the Blue Cross Blue Shield defendants would not be thrilled about me getting into a room alone with David Boyce at the beginning of the MDL and having him explain to me all the things and strategies and benefits that he would bring to the table and what his strategy in the case was. So I had my special master assemble a team, and they interviewed all the people that had applied to be lead counsel, interim lead counsel on both tracks, the subscriber track and the provider track. You can use special masters for discovery, and quite frankly, they can oftentimes get some things done in discovery through compromise and negotiation that the court just can't accomplish. They can build relationships. I know Randy does this, build relationships with all lawyers where she's viewed as a neutral. And, you know, the idea is she's probably going to be slow to speak on some qualitative or quantitative advice, but she builds up a relationship and is able to do that. You can have them involved in other just court management issues. You know, making sure the trains are running on time, setting the agenda for the upcoming status conference for MDL, being maybe a pressure relief valve when there are conflicts between lead counsel and other counsel in a case. So one of the questions that we had was, hey, I've got an MDL in Florida. I'm in Pennsylvania, I think it was. My case was transferred to an MDL in Florida. Should I hire local counsel? Well, no, not necessarily. What you ought to do is make sure you reach, if there's a special master in that case, reach out, and that special master would be more than happy to hear from you and hear any concerns, questions you have. I know Judge Fowle in the Eastern District of Louisiana at every status conference has a time at the end where he says, I'm obviously, we have to be led by leadership, but are there any other lawyers who have questions or concerns for the court? This is your opportunity to be heard. So, you know, this is almost like minority shareholder rights. We have to make sure that those interests are protected as well. And I think a special master is very well positioned. Now, let me be clear. There are some judges that are concerned about special master appointments. And I understand that, but I think, and a special master is not appropriate for every case. Clearly, there are certain cases where Randy, if you called Randy, she would say, I don't think you need me on this one. But there are cases that scream for a special master. And I think that one of the key things that I would suggest is the court needs to build into the special master appointment letter the ability for the court to communicate in camera with the special master. And you look, you have to trust us on this. We're not going to be involved in discussion about merits issues or who we like and don't like, but there are certain things that there's just that partnership can bring that resolve a lot of these issues. I have a few other thoughts, but I know we're pressed on time, so I will hold those in case there's a question.
Perfect. Thank you so much, Judge. Let's go ahead and move on to the next slide. Key terms and settlement agreements and MOUs. Peter, I have to raise a question. This is the most frequently raised question we've gotten so far for our webinar today, and there's a question here for us. Let me just ask you, are class actions dead in the 11th Circuit without the intervention of the Supreme Court or Congress? Thanks to this.
Right.
So regarding incentive awards.
Right. So every time there's a change or some ruling in class actions, a lot of people think it's the death knell of class actions. It happened when ATT versus Concepcion and the arbitration clauses. I think time will tell how much of an impact it's going to have. There's probably going to be a petition for writ filed in the Supreme Court on that issue, whether incentive awards for class representatives are unlawful. So it's unclear. I mean, there are clearly class representatives who will sign up for a class action without expecting an incentive award, clearly. And there are others that are going to expect an incentive award. I mean, people sort of don't realize that a class representative is a typical litigant. He is going to be interviewed by his lawyers. He's going to produce records throughout and discovery throughout the litigation, and he's going to be deposed and eventually may actually proceed to trial. So, and again, the incentive awards that we're talking about are incredibly reasonable in this day and age. They typically range in a consumer class action between $2,500 and $5,000. So, short answer to your question, time will tell what impact this is going to have, because the Supreme Court may do two things. It may reverse the 11th Circuit, or it could be even more unfortunate and essentially apply the 11th Circuit's rationale and ruling across the country. And that's the risk that plaintiffs' lawyers are taking by filing a writ before the Supreme Court. But again, the bottom line is it'll depend, and the future will tell what kind of an impact it's going to have.
Thank you.
Peter, there's one other possibility, and that is they may just deny the writ.
That is, Judge, I mean, I think that is probably, in my opinion, I think it could be a very likely, but the issue is, and I think there may be a split in the circuits on this particular issue. So it's not simply, so I think there's at least one other circuit that may have held otherwise to the 11th Circuit. So there may be a split in the circuit that may take it. I have no idea, but time will tell.
Well, and I don't want to speak out of school, but I served on the panel for up until 2020, and then last year was appointed to the advisory committee on civil rules, serve on the MDL subcommittee on rules, and I know that this has not gone unnoticed by the civil rules folks, particularly those who just finished up some amazing work amending Rule 23. So that's another avenue of review where there's at least some people advocating to the Rules Committee that we ought to amend Rule 23 to make clear that incentive awards are permitted. Now, again, I'm not getting into the merits of that debate. I'm just saying that that's at least on the radar.
Interesting. Thank you. So Lance, let me just cover quickly kind of some of the sort of key issues that I think come up in settlement agreements. And you know, it's funny because most MDLs, as everybody knows, statistically end up in settlements, and class actions really 97% end up in settlements. So settlement are important. Having said that, I see a trend of class actions actually being tried. GM, for example, is trying a case in California right now. And there was recently a verdict in a common issues class action, I believe in Michigan, that FCA just finished trying. So there seems to be a slow trend, at least in auto defect cases, of trying some of these class actions. But settlements are really, you know, primarily what happens at the end of either a class action or MDL. And I'll start with this statement, and that is that you know, not everybody, litigators are not usually geared to settle, because our focus is, you know, making sure we have evidence on liability, making sure we have damages. So our focus tends to be win, 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 and get your case ready for trial. I do think that it takes some creativity and sort of stepping back from your sort of trial lawyer hat, litigation hat, and try to put together a settlement. It's actually counterintuitive for the kind of work that we do. So I've learned that over the last, you know, decade in dealing with both plaintiff lawyers and some defense lawyers, and especially one defense lawyer who I've come to know and become friends with, who's very creative, and he actually is brought in by a particular client to try to resolve class actions and MDLs. And as soon as he walks in, you know, I'm reminded of the guy in Night Shift, who was also always very creative and is always thinking. And he just comes in and starts with these concepts about let's do this and let's do that. And it's just great. And eventually the case gets settled. So my first point is that sometimes you have to step back from your trial lawyer litigator hat, and think creatively about how you settle this case. What exactly is it that you're seeking? What remedy you're seeking, and then go from there to try to reach a settlement agreement. I think one of the first issues that comes up is whether this is going to be a non-reversionary or a reversionary settlement. It's a sticking point because non-reversionary means that the defendant's going to put up a fund of a certain amount of money. And no matter what happens as a result of that settlement, that fund is not going to go back to the defendant. It's a little bit of a sticking point because the defendant knows that once it pays out that in a settlement, that money is not coming back. The other one is a reversionary, which essentially means that whatever in a claims made settlement, whatever the class does not claim, the remaining fund or monies goes back to the defendant. I mean, from a plaintiff's lawyer perspective, a class action lawyer's perspective, as well as from fending off any objectors or objections, non-reversionary is usually the best settlement. And, you know, the default rule for at least a lot of the class action lawyers, and in particular the ones who practice, I believe at a high level, is we want non-reversionary class settlements for our clients. Because even though if it's a claims-made settlement, for example, where the class has to make a claim, and let's say 10, 15% of the class makes a claim and there's money left, that money can be attributed or at least sent out again or back to the class. Whoever's made a claim gets a certain percentage. You can also do a cypre, a legitimate cypre, for the remaining funds. And, you know, when people, you know, say, well, cypre is really not going to benefit the class, it's not going to go directly to the class. Well, class actions tend to do two things. Number one, compensate your class members, but they're also one of their purposes is to deter bad conduct by companies. So in taking that money and not returning it to the defendant, you are advancing one of the purposes of class actions, which is to deter wrongful conduct on the part of corporate defendants. So the first thing is, and by the way, I work with class action lawyers, and there's some that will not do a that will not do a reversionary settlement. They will only settle cases on a non-reversionary basis. I'm not one of those. I think there are cases where you may have to, the only way to settle the case is reversionary. But I think typically the default rule is it's got to be a non-reversionary settlement for us to settle. The other one is the nature and form of the payments. Again, you know, in a perfect world, you would like to have a class action that is claims paid, where the class doesn't necessarily have to make a claim, but simply receive the payment in the mail or by other means, versus a claims made where the class actually has to do something affirmatively to receive the claim. This is going to depend really on the nature of the settlement. A lot of the class actions that we have settled are claims made. I'll give you an example. In the Takata MDL, where I'm involved, it's a claims made settlement. So the class member has to actually make a claim. We thought that was the appropriate way to go, because we did not simply want to send a check to a class member and have that class member continue to drive a car with a defective and dangerous inflator or airbag in it. So we made it a claims made settlement because we wanted the class member, in order to receive compensation and to incentivize that class member to bring his car or her car in to have the inflator replaced, to make a claim. So in that settlement, we sort of were kind of like in unison with the defendants. We wanted to get the defective inflators out of their car. So we made the class member file a claim, get the inflator removed from the car before they received a compensatory payment in the form of either $500 or eventually a residual payment that would be left over in the settlement. So again, it really depends on what it is. And sometimes claims paid settlements where the class member doesn't have to make a claim. We had an MDL here in Miami, the checking account overdraft. It was claims paid, so we mailed checks to the class members. When it was all said and done, we had, I kid you not, about $80 million in uncashed checks because the checks were of, let's say, $25, $50, and some class members simply did not cash those checks. So it really depends on the nature of the settlement, whether it's a claims paid or claims made. I'm going to just talk briefly about the payment of class counsel's fees. We traditionally will ask the defendants to agree, and a lot of them do agree that class counsel get paid after final approval, as opposed to after all appeals are exhausted. There's case law support for that. One of the reasons we do it is because it deters the number of objectors that will file objections, especially in consumer cases. So traditionally, class counsel, not traditionally, because actually in securities class action cases, the class counsel usually get paid after final approval. In other cases, less so, they get paid after all appeals are done. But we have successfully discussed with defendants getting paid after final approval because it does deter objections, and it gets money to the class quicker the fewer objections that are filed. I'll just say this about objectors. It's every time you draft a settlement agreement, you have objections and objectors in the background. So you need to be careful as you draft your settlement agreement that it's going to basically thwart or protect both the defendant and the plaintiff's lawyers from any objections. So that, I think, is sort of just my sort of key points on some of the key terms in settlement agreements.
Thank you so much, Peter. In a few minutes left, let's go on to the next slide, Kathy. We did get a couple of other questions. One I thought was interesting is there some importance to presenting a a mediated settlement to the court? Is that a preference on litigants' part in relation to, you know, getting approval from a judge for a class action or an MDL?
Yes, I'll jump in. So in 2018, Rule 23 was substantially revised, particularly as it relates to settlement of class actions, objectors, and some other key factors. And one of the things that the Rules Committee did, and I think very wisely, I think Judge Bates and Judge Dow in particularly took a substantial lead on this. Not all the credit, but a lot of the credit, in terms of front loading the information the court has on a preliminary approval of a class. That's key, because what happens after preliminary approval of a class settlement, the notice goes out. And oftentimes we were learning that judges didn't have all the information they needed to have. Notice was going out. We're going to a final fairness hearing, and some defect in the settlement that was raised by an objector or otherwise detected by the court would have been readily apparent if we'd had more information front loaded to the court on preliminary approval. So the idea was, let's get this information up front. I think that's the first cousin of having a mediator involved in a class settlement. I tell my counsel in class actions, folks, I'm not saying I don't approve you if you don't have a mediator, but I feel a lot better if I know there's a good, solid mediator who knows his or her stuff involved in protecting the interests of the absent class members. And that's the key, is we are now settling a case involving parties who are not before the court. They're being represented, hopefully under Rule 23A4, but they're not before the court. And I think that it's helpful to make sure that we know exactly what the agreements were, that there's a mediator shepherding through. Mediator gives us an affidavit or other testimony about why this is in the best interest of the class, the party's good faith efforts. There are no side deals or under the table deals that are in some way problematic. And I think that the money you spent, and look, I know mediators, they don't work pro bono in class actions. But I think the money you invest in that, if you want to resolve your case and get it approved, is well spent. That's my just personal view.
Thank you, Judge. Thank you. I was going to say, I think we're just about out of time. I mean, we could go on for many more hours here, but I want to thank the fantastic panel today. Thank you so much for joining us. Thank you for your insights. Thank you for your wisdom. Thank you for your experience and the time that you spent with us today. Thank you to all our participants. There is a Florida Bar course number. The number is 220649-4N for Florida lawyers seeking CLE credit. I apologize if we didn't answer all your questions today. We will be sending out some emails from some of the panelists addressing some of your specific questions. So with that, I think we'll conclude our webinar this afternoon. Thank you again so much for being here.
Thank you. Appreciate it, everybody. Great job.
Thank you.